Hello friend, welcome to all of you. This is chapter number 3, Paying Banker, and the lecture number 4, the payment of fraud check and the negligence of paying banker 3.4. The previous lecture we discussed about the rights and duty of paying banker, and also we discussed the statutory protection to paying banker. And today we discuss the another point of this topic is the fraud check and the negligence of the paying banker. So this topic, there are some point are the important definition, meaning of paying banker, precaution in payment of the customer check, right and duties and paying banker. And previous lecture we see the statutory protection to paying banker. This lecture we discuss on the payment of fraud check and the concept of negligence of paying banker. So definition of check, the Negotiable Instrument Act 1881 section number 6 is given the definition of check. Check is an instrument drawn on specific banker ordering to pay specific amount to a specific person after a debt. So check is always drawn on the banker and is specific type of the amount to specific person. So as per the Act section 6, a check is bill of exchange drawn on the specific banker and not expressed to payable otherwise than the demand. So whenever the customer present the check in the counter and the demand for the money, that time only the payable the money throughout the paying banker. So what is mean by the fraud check? Fraud check means the check signed by an unauthorized third person who is not a real customer of the bank. A fraud or unauthorized signature is wholly inoperative and no right to enforce the payment or give a discharge therefrom can be acquired. So in simple term we say that whenever someone want to cheating to bank or the drawer, he make a duplicate signature on the check and present for the payment in the bank. That time its check is called a fraud check. The real owner of the negotiable instrument whose signature is fraud is in the same position about the fraud check. His right remain the same. The banker is required to take necessary precaution in respect of payment of fraud check. Such payment is the illegal, and that's why the bank need to take proper precaution about the fraud check, because somebody else want to cheating to draw or cheating to the bank. That time the customer claim on the drawing for his compensation for his the loss. The banker should stop the payment if he has the doubt about the signature on the instrument. The specific signature is provided by the customer into the bank. That's why the bank match the customer's check signature with their specific signature, and if the bank have any doubt, that time bank asks to the another signature on the document or the refuse the payment of check. The payment of fraud check by the mistake result in the loss of check the issuing the party. The payment of fraud check by mistake is means the loss of the customer credit, loss of money of the customer. That time customer claim for compensation for paying banker. In this case, the bank will be required to make the compensation of loss. The account holder will be entitled for recovery of money paid by the mistake. So account holder try to recover his money, and that's why he claiming on the drawing or the bank for recovery of fraud check. So what are the things looking back into the fraud check by paying banker? The paying banker should carefully ascertain that the check bearer is a genuine signature of their customer. Drawing after the comparing the specimen signature which is provided by the customer, the check must be signed by the drawer on its face and not its backside. The account holder has the right to change his signature, but he informed to the bank, and then he can change his signature, provide a fresh specimen signature. And the banker is bound to accept new specimen signature with the effect from the provider of the debt. However, the banker must refuse the payment of the check if the signature on the check is differ from the specimen signature. That time bank can refuse the check for the payment. This is because the check with the false signature of the drawer is the nullity and means the refuse, and give no mandate to the banker make any payment. So if there is the false signature and no mandate, no instruction given to the bank about the payment, that time that take care for the payment of check. It is to be noted that the payment of the check with the fraud signature of the drawer is the deemed, and the payment without the authority of the customers, and hence it is the breach implied the contract between banker and his customer. So there is the end of the contract between the banker and the customer when the fraud check payment is given. So there is the end of the contract between customer and banker, a breach implied. So there is the need to take a proper precaution about the payment of the check. Thus the paying banker pays the check with the fraud signature of the drawer. He gets no kind of the protection in the law when the fraud check's payment is given to the third party. The banker cannot debit his customer account with the amount of check bearing the fraud signature of the drawer and will be bear loss himself. So whenever the fraud check payment is given by mistake by the paying banker, that time it is a loss of the customer credits, and that's why he claiming on the compensation bank, and there is the loss of the bank's payment and the amount. So these are the things essential into the check. So another thing is it is the paying banker who bear the liability even if the signature of the drawer was so cleverly fraud that is was difficult to detect with the reasonable degree of care and scrutiny. Sometimes the fraud check there is the nearly same to same signature made by the fraudulent person. That's why the bank is difficult to find out. But there is the liability on the bank to check the all the details, or if he has any doubt then refuse the payment. It is for the safer for the customer payment and safer side for the paying banker also. Further, the banker is not absolved of his liability on the fraud check even if the customer was negligent. Suppose the not keeping into the custody safe his checkbook in locker and the key as required by the rules the bank. In the other one, the negligence the part of the customer did not absolve the paying banker. So negligence of the customers not is allowed to the bank. They not done their duty properly. If the negligence of customer, then the bank also not same things is done that the negligence bank looking the proper precaution and looking all these things before of the payment of customer. However, the customer is the under an obligation to the banker is regard. The customer should not be negligent in observing the necessary precaution to save the banker from the loss which may be arise because his won't act. So customer need also to take proper precaution, save his the checkbook in the custody, save his the signature and the protect to bank and himself. So another thing is important in about the check. A banker, if the doubt about the signature of the drawer, he seek the confirmation from the customer to calling to the customer about the what he actually is given check for the third party or pay or not. The customer express represent that the signature is his whole. The later on the customer will is stopped from the denying the validity of his signature on the check. So when the customer given the confirmation, that time bank forward the check for the payment. In the same way, if on the check the customer's signature is differ from the specimen signature, but he write the banker about his issuing a check bearing a different signature, such intimation will amount the confirmation of signature of check. Sometimes by mistake the customer's signature is make a difference between the previous specimen signature and this signature. That time in the case of the confirmation, the intimation of the customer, that time bank can not liable about the fraud check. Bank can issue the check or given payment to the third party. If the customer has the reasonable ground to believe or has come to know that check is the foreign signature, is going the present for the payment. So it is the duty of the customer to inform their bank immediately, avoid the loss of banker and avoid the loss of the customer also. And necessary thing also, the sometimes the such estoppel arise from the silence on the part of the customer. In the case of fail to inform the banker about his signature on the check has been important, the banker lost his right of the action against the forger, and the customer is stopped from the denying the genuineness of the signature. Silence part of from the customers, if he not informed the within the time to the banker, that time the loss of both customer and banker. In the case of joint account, both or all signature, all party check must be genuine. Even if one of the signature is the fraud one, the banker should not make a payment, otherwise he cannot be debit his customer account. If he doubt any about the signature, he can call all the parties for the signatures, and that time it is the important. So about the fraud check, to guard against the possible forgeries, the bank generally issue the requisition slip the before of the payment. The requisition slip is the important, duly numbered so as to indicate the name of the customer whom the checkbook is containing the requisition slip has been issued. So requisition slip is filled up by the payee and the customer. It is the important to safeguard the bank. If the requisition slip is the stolen, means the checkbook or the prescribed form is the stolen, thieved somebody else, the customer signature is forged, thereon the ambiguous the thief means the intentionally thief, and the banker issue an account the liability for the loss. This caused the until recent times depend on the rule laid down. The whenever one or two innocent person must suffer from the act of the third, he who has the enabled the such third person to occasion the loss of must sustain it the both parties. So here is the we see the about the project. The next is concept about the negligence of paying banker. Meaning of the negligence. Negligence in the all this respect would be amount to be failure to carry out the duties and responsibility of paying banker. The banker for such negligence will be have suffered paying the damages or loss of cause of the customers. So by mistakenly paid by the amount to the pay the check when duly required to do, and the default of such payment must be compensate the drawer for any loss or damage caused by the such default. So default or by mistake of the paying banker, the fraud check is given to the third party or pay. That time this amount is compensated to their customer because of the negligence of the bank. In the bank side, there is the negligence of the banker. That time bank must pay the compensate to their customer according to Negotiable Instrument Act. So care must be taken to the banker. He should be make sure that the customer account has not been the debited mistakenly with any check draw on the other account, not deposit in other account. The banker must certain that the no post dated check draw by the customer has been the permanently debited. No post dated on stale check payment is given is necessary. The drawing banker should be make sure that no regular credit such salary, pension, monthly payment, quarterly interest rate, FDs, if the bank is as per the standing instruction etc. are the missing from the customer's account entry, that time bank take a proper precaution. When the missing of the interest rate entry, the pension amount or monthly amount. In the case of missing it is necessary to check out whether they are wrong or credited or some other account or some other customer by mistakenly paid to the other person. It is the negligence of the bank. So summary of this lecture, what we are looking in this video. A fraud check means a check signed by the unauthorized third person who is not a real customer of the bank, and they intentionally they make a duplicate signature on the check for cheating of bank, cheating or fraud. It's called the fraud check. The banker is required to take necessary precaution in the respect of payment of fraud check, and such payment are the illegal. And negligence in all these respects would be amount failure to carry out the duties and responsibility of paying banker. The banker for the such negligence will have the suffer paying damage or loss of causes of the customer. That's why the bank need to compensate their customer about the negligence. So references for this point: the Riley publication book, and you can use the Success publication book for your study. The next is the about assignment question. What question will be asked in this topic? Explain the concept of fraud check and negligence of banker. What type of the precaution taken by the banker about the fraud check? This question will be asked in the term exam as well as your final examination. So here we end this lecture. Thank you for watching this. In the next time we will be see the last point of the topic number 3, paying banker, the reasons of return of the check. Thank you.